We need to make a correction to the record before we get started.
You just finish introducing the case and then we'll take up any issues.
You bet.
And then also appearing, we have Timothy Peterson and Shelley Peterson appearing pro se. All right, so as I stated, we're set for hearing on the motion. So Mr. Peterson, you believe there's some issues we need to address first?
Yeah, I've got a couple, couple three, Your Honor. Before we begin with my introduction, are we in a constitutional court of record?
I'm not sure I know what you mean.
Are we in the public record?
Yes.
Okay. So therefore, this court is a constitutional court of record. Then would you agree?
It exists under the Constitution of the state of Kansas, so I suppose that's correct.
Okay. All right. Thank you, Your Honor. And we are here sui juris, not pro se. Um, and then underneath the UCC 1-308, we reserve our rights under common law without prejudice. And no, Your Honor, we are not the defendants listed upon this court case. We are living souls and living bodies as living people upon the land, and as the sole executors and beneficiaries to the trust listed as the defendants in this case before the court, we are non-corporate citizens. We are U.S. nationals here in peace and non-combative in this constitutional court of record. And we appear only as a special divine appearance to settle the business matters before the court only. And also, Your Honor, as you have addressed, this is a trust issue. The defendants listed here today, so that was one of the corrections that we needed to have made that hadn't been previously read into the record. Before we begin, Your Honor, do you have proof of your constitutional oath of office to the people? And do you have proof of your oath of service? Because we require you to be in your oath of the Constitution to the people of service and to your oath of office here today.
Okay. Yes.
Okay. And would we be able to get copies of those? They didn't have that, nor your judicial bond copy at the Comanche County Courthouse.
They should. Those were circulated, but I can make sure those are provided to the clerk so you can access them.
Thank you very much, Your Honor. Um, in addition to that, um, as we are now uh, clearly in the jurisdiction of common law and underneath the Constitution itself, which is the supreme law, well, are you able to uphold your oath to the Constitution, Your Honor?
Yeah, so I've executed my oath, and that's of the record, so I don't know that that's immediately needed to be addressed today. So we do need to get on with the time that the issue that we're set for, which is the motion for summary judgment. So are there any other specific issues before we proceed with that, Mr. Peterson?
As this is our private, I would like to know, as these are the defendants, if you can see there, Your Honor, these are the defendants, which is our birth certificates, and also they are our minor estate trusts. Does anybody here present today have a higher claim to these trusts and to these birth certificates than we do?
Okay, so we're not going to continue with this line of questioning because it's not relevant to the summary judgment motion. So I think with that, I'm going to foreclose any additional quote unquote preliminary matters, and I'm going to turn it over to Mr. Grillo for any argument on his summary judgment motion. So with that, Mr. Grillo, whenever you're ready, if you have any additional argument, you may do so.
Yes, Your Honor. I appreciate the time and effort, the court allowing us to appear via Zoom. Appreciate the accommodation. For the most part, the response, the motion and memorandum in support, as well as the reply, set forth most of the arguments that American Ag Credit would be proffering today in detail. I think that the main thing that I want to point out to the court, and although I'm sure the court's aware of it, in a preliminary matter, we had a motion for judgment on the pleadings, and that Your Honor ruled on that on June 2nd of 2025 and identified specific issues that remained in the case that were needed to be decided based upon further proceedings. One had to do with whether or not payments or whether there was consideration for not just the original note in August of 2019, but also the renewals that were executed by the Petersons in 2020, 2021, 2022, and 2023, as well as whether or not there was any proof that said that the Petersons have paid American Ag Credit in terms of that in terms of its note and mortgage and security agreement. And Exhibit 6 to the memorandum of support, American Ag Credit produced a verified payment history, or essentially loan accounting for the line of credit the Petersons took out in August of 2019. That detail in Exhibit 6 shows all the loan advances that were made, as well as all of the payments that were received by American Ag Credit from the time of the inception of the line of credit in August of 2019 through the non-renewal of the line of credit effective on August 1 of 2024. And I think that shows the detail to the court that payments were made not just from the Petersons to American Ag Credit, but also that loan advances were made to the Petersons throughout the life of the line of credit. And it would be American Ag Credit's contention that shows adequate consideration for not just the original note, but also the subsequent renewals, as well as reflects the lack of payment that was received from the Petersons on American Ag Credit's line of credit. So in other words, it specifically addresses the two remaining issues that the court identified and shows that that everything was supported by consideration and that payment hasn't been made. More importantly, there was no contention in response to Exhibit 6, or no affidavit or other material piece of information or facts that were presented by the Petersons in their response to American Ag Credit's motion for summary judgment that shows that there's a dispute in terms of that payment history.
Objection, Your Honor. They received several negotiable instruments to pay that account in full, and they accepted them, never did return any of those. And by acceptance, therefore, that discharges the liability. The record, my paperworks are complete with that and has evidence that it's.
You'll have an opportunity to make your own argument here in a second. So if you'll let Mr. Grillo finish, then I will give you an opportunity.
Thank you.
Well, not in regarding to that, none of that information was presented in response to the motion for summary judgment. No proof was put forth, and I'm very confident that if Your Honor would review that negotiable instrument that Mr. Peterson refers to, it's not legitimate. It attempts to draw on some sort of Social Security trust on the Treasury of the United States to pay American Ag Credit the balance of its loan in full. And there's no consideration. There was no money that was going to be paid. It's just not a legitimate argument or payment. And so, but more to the point, in terms of the procedural aspect of this case, none of that was presented in their response to the motion for summary judgment. There's no dispute that American Ag Credit maintained a note, mortgage, and security agreement against the assets the Petersons owned. There's no dispute that the loan hasn't been paid. or no proof of a legitimate dispute that loan hasn't been paid, and that American Ag Credit is entitled to a judgment foreclosing its mortgage and security interests in the Petersons' property. As a matter of fact, American Ag Credit set forth 41 statements of uncontroverted fact, and not a single fact was responded to, not only in the appropriate fashion required by the Supreme Court, but in general. There was nothing in the responses the Petersons filed that shows that any of those specific facts were in dispute. But even then, it's not the court's job to ferret out those items in the record, which is why the rule is the way it has been implemented. And the Petersons were well aware of that rule because they faced the same issue